order this morning. I welcome everyone. I'd ask you to bow your head so that we, as always, begin our meetings with a prayer to thank you to our Lord. Darlene, Representative Taylor.
Thank you. Good morning, Heavenly Father. We thank you for the wisdom you've given us and for the ability to represent the people of our great state. Please bless these proceedings and let us live in your lifestyle. In Christ's name, amen.
Amen. I want to welcome everyone here this morning. As you know, we're having a hearing only in regards to the 3 bills that were posted yesterday. Also, let me state at the beginning of our meeting that I would ask you to turn off all cell phones or anything that might be disruptive throughout our meeting. Also wanted to let you know that after our meeting was planned and posted, that we go in today at 9 a.m. So we're going to do what we can within the time limit of which we have, and then we will proceed. If we don't have time to do everything intended today, then we will continue at our next meeting with that in that regards. So I just wanted to let you know that the time factor had changed a little bit upon us, and we need to be able to let the members of the General Assembly return to the House floor by 9 o'clock. So having said that, I have asked the authors of the bills to be present this morning, and both are here. And at this time, I would actually want to ask Representative Spencer if he will come forward and present House Bill 679, which is entitled the Georgia Constitutional Carry Act of 2012. And per our rules, Representative Spencer, what we do is allow the author to explain the bill in detail and go through it with us, and then we will take and allow certain time for testimony up to the point that we have the time to do this morning. So with that, please.
Thank you, Madam Chair. Can y'all hear me? Okay, what I present to you this morning is House Bill 679, and I gave you a new substitute before you that we were going to be working on, LC 286074ERS, and I made a small change to the current substitute, or the one that you have.
Why don't you go ahead, because if anyone happens to have a copy of the initial substitute that you gave us, which is LC 285952ERS, that they will know where that change is. So go ahead and just tell us where that change is.
All right, we'll start working off that substitute. Essentially what House Bill 679 does, it essentially removes the current permitting process to obtain or to carry a concealed weapon. Right now the current process is, if you are a law-abiding citizen, you have to go towards the appropriate court and get a gun permit, fingerprint, and pay essentially a fee or a tax to to essentially exercise your Second Amendment right. So that's what essentially House Bill 679 does. What also it does preserve the permitting process for the purposes of reciprocity. If an individual wants to go across state lines where Georgia has reciprocity agreements with other states, then they'll have to keep that permitting process as an option. So it doesn't totally remove the permitting process, but it keeps it intact for that purpose, because we do have to abide by other states' laws. So that's essentially what the bill does. And if you have any questions about the bill, we'll go ahead and answer those, and we can go into the actual substitute if you need to.
What I'd like to do is make a statement in regards to what you were saying about going across state lines there is a bill for Congress that you may be familiar with that actually has passed the U.S. Congress, that they're trying to make sure that if you have permits with carrying a gun, that there's 49 states that I believe have permit requirements of some type, and that particular legislation from the U.S. House would allow so that all states would honor the permits as you go across state lines, even with their change of power, is my understanding from one of our American Hunter magazines, kind of thing. So I just wanted to follow up with the statement that you had just made. And I think, yes, we would like for you to go through the substitute of which you're offering to this committee.
Okay. What you see before you on LC 285952ERS, we essentially, in the first part, we essentially tell the law that says This is about our gun rights. This is about an inalienable right, the Second Amendment, and this bill operates under the premise that the permit that you abide by is your Second Amendment right. So that's essentially what the bill does in the first part of the bill. As we move on, we start to change the definition of lawful weapons carrier. We start that at line 55. And as you can see there, it includes law-abiding citizens. If you are a felon, it does not include you as a lawful weapons carrier. That's essentially what this bill does at this point. We went and sort of made changes within the code since we defined lawful weapons carrier, and it sort of tweaks the code a little bit all throughout the code to keeping the lawful weapons carrier definition consistent within the code. That's essentially what it does at this point. Other than that, there's really essentially a simple change in the code with regards to that particular definition.
It's about the bill while you got the floor. You will have it again, but if there's something else you want to
just
state.
the fact that that's simply what it does. It just is really a simple change in the code.
Okay. Any of our committee members have any remarks or thoughts or questions to Representative Spencer? Okay, Representative Taylor.
Thank you. When you're in this section 3, and you're talking about right now it is requires a permit, and even in some places with the permit you cannot go, like a park, a historic site. You want to remove those. Does that include like the Capitol? That's
It
a
does
historic
not.
site.
The bill does not change the locations where you're prohibited from carrying a concealed weapon. The bill does not address that.
Okay.
We've stayed away from that. All it does is remove the permitting process. We do not change the places in which they are prohibited. It does not touch that part of the
Schools,
code. Right.
things like that. All
Right.
that stays
It
intact.
doesn't do campus carry. It doesn't do anything in government buildings. So we do not change the location of that. All
Thank
it
you.
changes is the definition of lawful weapons carrier.
Okay, thank you.
Any additional questions to the author? All right, seeing none, Representative Spencer, thank you. We have got several people that have signed up that would like to speak in support of the bill. And if you would please, because of the time constraints that we're in, go ahead and form a line up and give your name. Those that would like to speak in support of the, I'm assuming the substitute that has been presented, LC 286074 ERS. And if you're not speaking to that one, just sort of let us know. If you would please identify yourself, and just remember that our rules state that we have 3 minutes for our testimony, as it is in the committee always. So please.
Good morning, members of the committee, and thank you, Chairman Purcell, for holding this hearing. My name is Nathan Adams, and I am an interim state coordinator for the Georgia Campaign for Liberty, a nonprofit, nonpartisan, grassroots organization made up of thousands of Georgians who are working to lessen the burden that government regulations and controls put on individuals in this state on a daily basis. I've come here this morning to advocate for an up or down vote by this committee on HB 679, and that does include the substitute bill you've been presented with, also known as the Georgia Constitutional Carry Act of 2012. I believe passionately that we have a God-given right as individuals to defend themselves and their families with a firearm. This right is inherent. It's not granted by any politician or elected official. And in the case of self-defense with a firearm, I do not believe that individuals here in Georgia should be required by law to carry a Georgia weapons license in order to carry a firearm openly or concealed. I believe that a Georgia weapons license should be optional, not mandatory. Criminals do not stop and ask for permission to carry firearms. They have never done so, and they never will. For close to 150 years, legislators who have served in this body have slowly chipped away at our Second Amendment rights in Georgia. And in many cases, those decisions were made to prevent certain residents of this state from possessing firearms simply because of the color of their skin. This is a fact that just can't be ignored. Today, residents of many of our cities and towns live in fear of crime in their streets and their homes because the criminals do have weapons, and they are not, and those law-abiding citizens are not allowed. This is a travesty, to say the least. Many folks who wish to carry a firearm in various parts of the state simply cannot afford to pay the tax and go through the process. Taking a day off of work to suffer through a bureaucratic process at the probate court and pay a fine simply isn't an option for these folks. It's kind of an act of arrogance to say that the elected officials can think they can prevent crime simply by forcing law-abiding citizens to pay a tax and obtain a license. So once again, I've come here today to advocate for an up or down committee vote on HB 679. I believe this bill will make our cities and towns safer and return the God-given right to individuals in the state to defend themselves and their families without the need for government permission. For nearly a year, we've been advocating for this bill, and we will continue to do so. A pro-gun vote in favor of HB 679 would be treated with nothing but support, but a vote against 679 or refusal to allow such a vote would be treated as an anti-gun action. I implore the members of this committee...
Your 3 minutes are up, but we'll be glad to take any other comments that you have and place them in our record.
Thank you.
Thank you. Appreciate you being here.
Hey, my name is Patrick Parsons. I'm the Executive Director of Georgia Gun Owners, a nonprofit, nonpartisan, grassroots gun right organization based in Kennesaw, Georgia. Our mission is to transform Georgia into the freest state for gun owners in the entire country. 2 years ago, close to a dozen gun rights activists joined together to form Georgia Gun Owners. The formulation of Georgia Gun Owners centered around a dissatisfaction with the state of gun laws in Georgia, specifically the lack of any leadership from the institutional gun lobby towards the passage of a constitutional carry law in Georgia. What would constitutional carry mean to Georgia gun owners? Constitutional carry would decriminalize the practice of carrying a handgun openly or concealed without a permit for those who are legally eligible to purchase and possess a handgun under state and federal law, and otherwise grants the same authority to carry as enjoyed by permit holders. Constitutional carry would not repeal or otherwise change Georgia's existing concealed weapons permit law, would not authorize the carrying of a concealed handgun by felons, the mentally ill, juveniles, or anyone otherwise prohibited from possessing a handgun under state and federal law. It would not change where concealed handguns are allowed as defined by current Georgia or federal law. It would not affect permit holders' reciprocity agreements with other states in any manner. It would not affect the ability of prosecutors to pursue charges for other crimes. It would not have anything to do with the purchase of a firearm. More than 17,000 Georgia gun owners have signed the petition to pass constitutional carry in Georgia. These 17,000 include individuals from every single city, every single town, every county, and every state legislative district in the entire state of Georgia. Why has this issue struck such a chord with so many gun owners? The answer is simple. Gun owners are tired of being treated like criminals. As you may know, in order to get a Georgia weapons license, individuals have to travel to their county probate, fill out papers, pay a tax, get fingerprinted, submit to background checks, and in many cases wait weeks, if not months, to receive their license in the mail. I can think of no greater wrong done to gun owners. This should be a process reserved for criminals, not law-abiding individuals who seek to do nothing more than defend themselves and their families. Government permission should not be required for a constitutionally protected right. The idea that a person who is law-abiding would randomly begin committing crime just because they can legally carry a gun is ludicrous and is not supported by any evidence or any fact. It's a tactic of fear used by those who think it sounds scary to regular individuals. Because my time is limited, I would like to close with the following. The refusal of the chair of this committee to allow an up or down vote on HB 679 is an affront to gun owners across the state of Georgia.
I reply to you before you leave. There has been no refusal. Incorrect information was put out. There had only been one meeting of this committee, and it was an organizational committee meeting. The following Thursday, there was a meeting where one House bill was heard. This actually is the third time this committee has been meeting. No one has called me. There has been an assumption and incorrect information in regards to this bill not being brought up before the committee. So just wanted to let you know.
Right. Well,
But I do appreciate your opinion.
We look forward to that vote. We look forward to that vote.
And we will follow through as
Right.
the guidelines follow, and we will work out whatever comes to be.
Right. I'd like to finish my testimony.
And if you would like to submit your remarks and any remarks that you didn't have time to, you're welcome to do so.
Can I finish my testimony?
I think your timer just went off. That's why I intervened.
Thanks.
But you're welcome to pass those and share with us, and we'll share with our committee members. And thank you. Yes.
Hey there, how you doing? My name's Hiram Lincoln Madge. I'm just a free citizen of these United States. I appreciate the time. I don't have any notes or I don't have anything prepared for you guys, but I'm here in support of HB 697, I guess it is. 679, okay. And just for you guys, just want you guys to understand that I'm a concerned citizen and that our Second Amendment has been infringed upon, and it guarantees us the right to bear arms, and that has been infringed upon by the laws that we have currently here in this state. This bill that Jason has brought forward would help to alleviate that infringement of our rights, and so we ask your support. I ask your support on behalf of all freedom-loving Americans. Thank you.
Thank you very much.
Morning, Madam Chairman. John Monroe with GeorgiaCarry.org. GeorgiaCarry.org is a gun rights organization in Georgia with over 6,000 members. We support the bill. I just wanted to bring a couple of things to the committee's attention, and that we'd suggest in an effort to somewhat streamline the bill and make the code simpler, which is something that we've always striven to do, especially with the gun laws, which can tend to be complex and confusing. The bill essentially removes the requirement to have a license to carry a firearm, which I said is something that we support, but I think it makes it somewhat more complicated by taking Section 1611-126, which is the current law that requires a permit to carry a firearm, and modifies it essentially to say that if you're a lawful weapons carrier, you can carry a gun. And our point is, well, why not just repeal 1611-126? The purpose of that code today is to require a license to carry a gun. If the purpose of the bill is to remove that requirement, just repeal 1611-126. What it does instead is essentially change the crime to make it a crime to carry a gun if you're already not authorized to carry a gun, which we already have crimes for, and in fact they're generally felonies, such as a felon in possession of a firearm is already a felony, both state and federal, so creating a misdemeanor to address that doesn't really serve any purpose. So our suggestion would be to change Section 5 of the bill to simply repeal 1611-126. And then there are a few places then throughout the bill where it refers to the crime of an unlawful carrying of a weapon or long gun, such as in lines 223 and 224, and we'd suggest deleting those as well. Thank you, and if there are any questions, I'd be happy to answer them.
Do is to write down your proposals so that the committee has that opportunity to look at what you have brought before the committee today.
I'd be happy to.
Okay, thank you so much.
Thank you.
I do have a question. Representative Taylor?
Yes, sir. I would like
Sir.
to ask a question.
We have a question?
Thank you. Thank you for your comments.
Sure.
Were you consulted or have you talked with anybody about this bill? Or so are these new ideas?
I've exchanged some emails with the author, yes.
Okay, thank you.
Thank you. Any additional questions from our committee members? Okay, do we have anyone else that would like to speak at this time in favor of the bill? We have several people that have signed up to speak in opposition. If you don't mind, also follow the same procedure, and you will be under the 3-minute time period. Please come forward.
Thank you, Madam Chairman. I'm Howard Sills. I'm the Sheriff of Putnam County, Georgia. I'm the first Vice President of the Georgia Sheriff's Association and Chairman of the Sheriff's Legislative Committee. You won't find a stronger defender of the Second Amendment other than myself. I, like what some of these gentlemen said here today, believe that it is a right. It's for us to bear arms, keep and bear arms. And I depend on my citizens and my community, my good citizens, and have some comfort that they do have arms. I think that they would come to our aid when needed, and it's a very important, and I think it may be the most important right in our Constitution. I've been a police officer of some sort for 37 years, and the last 16 as sheriff. There's been no time in those 37 years when you did not have to have a license to carry a handgun in Georgia. I've looked back, I can't find any point in time in the last 80 years when you didn't have to have a license to carry a handgun on your person in Georgia, outside of the places that are permitted, your home and property and things of that nature. Our membership supported much of the provisions that changed a lot of the carry restrictions session before last, I believe it was. But we were adamant, and when we took a vote, that we were opposed to anyone being able to carry a handgun without a license. We consider it a public safety issue, and we are very concerned that many other legal impediments would result from that, and we're simply opposed to it.
Thank you so much.
Thank you, ma'am.
Anyone else that would like to speak to the bill, pro or con? Seeing none, we'll go back to Representative Spencer. Any closing remarks for the committee that you are appearing before?
Well, I just appreciate the hearing, and I'd ask you all to look at your conscience and looking within yourself that to protect our Second Amendment right is to remove all barriers. And government is not the giver of our rights. And remember that they come from God and our inalienable Creator. And even if you don't believe in a Creator, they come from our humanity. And I just ask you to search your heart, search your mind, because that's what this is about. Thank you very much.
Well, thank you so much for coming this morning and presenting the bill to us, and we'll be looking at it forward. Now we're here to also hear House Bill 827. Representative Hembry, do you want to do both bills at the same time so you can let people know the difference in those? Please.
Thank you, Madam. Thank you, Madam Chairman and members of the committee. Good morning. How are you? I've got two measures that I want to present today, House Bill 827 and 828. And they both basically mirror each other with one difference. But the reason I bring this before you today is currently in Georgia, eluding law enforcement is a misdemeanor unless 5 conditions are met. And I think it would be wise for us to make it simple and remove those conditions, and that if you elude law enforcement in a motor vehicle, then you're subject to a felony. And I think it's a good measure because I think it's good for protecting law enforcement. It also protects the general public in these high-speed chases around the state, and I just hope that the members of the committee will see the same. The difference between the two measures is that one measure that I would prefer to push forward is that you would forfeit the motor vehicle if you are convicted of a felony. So if you're on a motorcycle or an automobile and you are convicted in this manner, you will forfeit that vehicle. I think it's a strong message, and it sends a message to those people that they shouldn't be doing that, and hopefully it'll be a deterrent and be an effort to hopefully protect the general public. So that's the measures. I think it's good for all the citizens of the state, and I hope that the members will see the same.
Do I have any questions from the committee members in regards to either the House Bill 827 or 828 to the author? Representative Frazier.
Thank you, Madam Chair. Representative Hembry, can you explain to us on the committee what is the need for this bill and why do we need to make this a felony?
Well, just as a private citizen, I've followed over the recent years the high number of high-speed chases on the news and covering it in the newspaper, and I'm concerned about the general public in these high-speed chases and incidents occurring where innocent people become victims. And I think that we as a General Assembly should try to do everything we can to deter these type things. And I think this measure will send a message that if you're eluding law enforcement, then you're going to suffer serious penalties.
Madam Chair, a follow-up.
Please.
Have you got any input from our police officers or State Patrol and for the need for this bill?
I think so. There's some here today. I hope they'll speak in just a few minutes in favor of it, and so maybe they can share their views. But yes, they are supportive.
Thank you.
Any other questions from committee members? Representative Neal?
Thank you, Madam Chair. Representative Henry, I'm looking at 827, lines 27 through 34. Is it not already unlawful to impersonate? How does this change the existing law in impersonation of an officer?
And that's a good question, and I hope that the Legislative Council will maybe help me with this matter because we discussed this.
That'll be fine. Ms. Long?
There are no changes. This was placed in the bill word for word. The reason it's all underlined is the organization of the statute was so much that we elected just to rewrite the entire first part of the provisions and put it in as new. But this is actually paragraph E is word for word what is an existing law in this code section. It just happens to be in the same code section.
Okay. Thank you.
Thank you.
Thank you. 17. Okay. Who is that? Cook. Representative Cook.
Thank you, Madam Chair. Representative Henry, just one quick question. I'm supportive of 827. Just a question about, I guess, 828 with respect to the forfeiture of the vehicle. What happens with this, I guess, this new change in code to where, say, for instance, I'm in Billy's car, I take it and I flee and elude. Does he then forfeit his vehicle because I was in it?
Yes. Well, if you look through here, there's language back here that says that the district attorney must go through steps and procedures to notify or to let it be known if there are lien holders or if the vehicle is owned by someone else. And if they were not aware of the seizure of the vehicle, then I think the vehicle would remain with the owner. If I can get some clarification, if I can get some clarification with that.
As is currently written, the owner is only responsible if someone else is driving if they had reason to know that the individual was fleeing or likely to flee. So there is a specific involvement of some sort. It would be a very difficult standard and probably not likely to happen.
Thank you.
Any additional questions to the author about either bill, House Bill 827 or House Bill 828? All right, seeing none, what we're going to do next is have anyone that wants to testify for this bill or against. But first we will hear for the bill. So if you have elected to speak or wish to speak, please just form our groups here and make your explanations. Well, go ahead and identify us again because we're on a different piece of legislation.
I'm Howard Seals, the Sheriff of Putnam County, First Vice President of the Board of Sheriff's Association, and Chairman of the Sheriff's Association Legislative Committee. Obviously, we are in favor of this. These chases are perpetually endanger the public, and somehow it frequently gets turned around that we in law enforcement are responsible for it. The people responsible for hurting people in incidents where they are eluding law enforcement are the people driving these vehicles. and they are the ones that need to be held accountable. And I can't, it's a very serious matter, and it should be a felony. It is. It is in most states, and to here now with our new things, you've got to be driving so fast or something like that. But these people are responsible for what happens, and it's a serious thing, and they're usually running because of some other serious matter also. As far as the forfeiture, I can tell you, ladies and gentlemen, that nothing has been more effective in my career than our ability to seize the assets of criminals. They're not worried about getting a 5-year sentence, folks, because they're going to get out in a year, 18 months. But when you take the property they use to facilitate a crime, it hurts them. And the provisions are in this bill where you will not be able to take somebody's vehicle that doesn't know what's going on with that vehicle. Thank y'all again.
I'm Mark McDonough. I'm the Commissioner of the Department of Public Safety. Every year, troopers are involved in over 400 fleeing and attempting mainly high-speed pursuits. When a trooper pulls over a vehicle, he has probable cause that there's been a violation of the law. It's then the citizen that decides that they're going to flee. The author used the term innocent life. Once that person makes the conscious decision to flee, they are placing innocent life at jeopardy. Your daughters, your sons, your parents, your relatives. The penalty for placing innocent life in jeopardy should not be a misdemeanor, nor should the officers of the state, despite the department that they work for, have to be put in that position to make those split-second decisions, because that's what it comes down to for them, a split-second decision. When they do that, their life is put in jeopardy to perform their duty. Now, folks would say, that's an expected part of the job. That's what you signed up for. And that's true. But when that citizen makes that decision and they have to do that, everybody's at risk. So when innocent life is placed in jeopardy, that shouldn't be a misdemeanor, in my opinion. As far as the forfeiture is concerned, Representative Horn, what kind of car would he be fleeing in? A Jeep? We wouldn't need your Jeep. But, and I think the bill lays out that the process of forfeiture, would be in the hands of the decision-making of the courts. That's where it is with all, with all property, and that's the place that it should be. But we are in support of the concept of this bill. Making this a felony makes it serious, makes the consequences of fleeing from, the law a proper consequence. Thank you.
I have a couple of questions, if you don't mind waiting just a second. We've got Representative Fraser.
Yes, thank you, Madam Chair. Can you explain to me what is the age limit? What are we doing for the minors that flee? A lot of them take off and they flee from you also. Are they going to be charged with felonies or misdemeanor?
When a minor gets a license, he's held to the same responsibility as an adult, because the consequences behind the wheel, whether he's a minor or adult, are the same. That's the reason why we have a license to grant them that privilege to operate an automobile. So the consequences would be the same.
Thank you.
Representative Taylor?
Thank you. When you indicated the courts will decide who gets vehicles that are taken possession of, what grounds do they use it? I'm thinking of a child using the family car, and who would eventually get that vehicle? Does it go to the court? Would it go to public safety? Who, or the local sheriff? Where would it go?
The court can usually make a decision of how it's going to proceed, whether the vehicle is something that could be used by the agency, or whether it would be put up for sale, and then the court would decide the distribution of those funds.
Thank you.
Any additional questions from our committee? Thank you, Colonel, so much.
Thank you, ma'am.
Next we have...
Thank you. Ladies and gentlemen, my name is Frank Vincent Rotundo. I'm the Executive Director of the Georgia Association of Chiefs of Police. Actually, this is something that's been addressed many, many years, and it's a concern of my members, because often they're involved in civil litigation when they get involved in vehicle pursuits. So from a management standpoint, that becomes a real issue. From a management standpoint, we've actually had committee papers written on vehicle pursuits, when to terminate those pursuits. We have suggested policy from the law enforcement perspective as to when to terminate pursuits and when to start pursuits. Also, courts have dictated some policy to us and guidelines. All of that aside, people still feel the need many times to elude police. And I do believe it is a tragedy when they do that, because it often causes the law enforcement officer to put themselves as well as the citizens in danger. To make it a felony certainly should make it a curtail, or should curtail the ability of those people to go forward or even think they're going to get away with it. We also have to have faith in the system that if in fact somebody's arrested for a felony, that the courts will look at the aggregate situation involved and make a determination as to whether to deem that person to be a felon or not, or to dismiss the charges. Now, I've heard this testimony before, because we've had many people put in bills similar in nature. This is very simple, and it's a good bill, and I do appreciate it. The only real negative that I've ever heard that was substantial, which could be rectified by the court, was the parent who was very afraid of their young youth, who was afraid that a police officer was unjustly stopping their youth and sped a little bit. Like, what is really a pursuit? And really, we have policy guidelines that govern that, and that's a decision that the courts will have to look at. Is, was it actually called a pursuit? Was it a pursuit when a person didn't stop 5 miles over, 10 miles over? Solidly, those courts can make those decisions, and we have to allow the judicial system a little wiggle room. This is a very good bill, and hopefully it will curtail vehicle pursuits. I am also, in my closing statement, going to say a lot of law enforcement officers die in vehicle pursuits. And once again, as a law enforcement manager, I'm very concerned about them. In fact, so much so that I've been communicating with the International Association of Chiefs of Police, who also have paralleling concerns and have been able to gather data over the years when they look at officer deaths, and able to tell you that a large percentage of those deaths occur in vehicle pursuits, needless vehicle pursuits. I thank you for favorable consideration on the author's bill.
Thank you. Any questions from committee members? Seeing none, thank you. Is there anyone else that would like to speak for or against House Bill 827 and House Bill 828? Seeing none, we'll go back to the author and ask him for his closing remarks on both bills.
Thank you, Madam Chairman.
Oh, wait. Can you hold just a second? I do have a question here. All right, Representative Jackson. Oh, Representative Neal.
I'm on 26. Yeah, my question is for the author. Is there a way that something can be added into the law that makes it where once a vehicle is seized, that the agency or department that initiates the pursuit or what have you, the funds or the vehicle goes into the direct budget of that department or agency, instead of being instead of giving the judge the discretion to either give to the agency or elsewhere? Because, for instance, if a department seizes or does all the grunt work and everything after having a pursuit or what have you on a vehicle, they sell it, say they sell it and get $30,000, and say the department needs the $30,000, but the judge or whomever thinks that the money should go somewhere else, if there is something that can be written to make it where those funds go directly to the agency that did the work on it.
I'm certainly okay with that. That part of it, the intent though here was to deal with the eluding the officers. You know, the other part of the forfeiture and the processes thereafter, I'm certainly open to any possible changes. I was just following whatever the current law is for forfeiture, and so that's why.
If I could reference counsel, is that something that could be an amendment?
Will you please give us your legal opinion on that?
I might direct the committee to line 115, and this was added a little bit different than what we normally see in law, but that the proceeds would go to the governing entity of the law enforcement agency that made the stop and made the seizure. While we're not going to, I guess, tie the hands of that entity, we did express legislative intent that that money go for law enforcement purposes.
Is the shall, I guess, as the operating word, is that definitive, or is it?
Yes, it is. The court would not have discretion where that money went. It would have to go to that entity as it is currently written.
Okay.
Now, I could change it to go to the particular law enforcement agency, but it would actually go through their budgeting authority.
Okay.
Any other comment, Representative Neal? All right. Would you like to make the closing statement? I don't see any more lights up here for questions.
Sure, Madam Chairman. Again, I really can't say the ones who spoke here spoke more wisely than me, and I just hope that you'll consider this measure, and thank you for your time.
Any additional comments from our committee members? Any of the bills? Holcomb, Representative Holcomb.
Thank you, Madam Chairwoman.
Sure.
Representative Hembry, I'm very supportive of what you're trying to do here, and while reading through again this morning, I just did some quick research, and one of the things that we may want to consider is, especially in light of hearing the testimony from our public enforcement officials, would be to make first degree, second degree, third degree levels, and the first degree may be for those that result in the death of either a police officer or of any Georgian, and then maybe second degree harm to property, and perhaps have classifications of the harm that's caused by. I've noticed that in Michigan, that's how they do it. In other states, it's ways that they break it down for something to consider. But either way, I think that this is a bill that's very much worth approving. Thank you.
I was trying to make it as simple. I really was trying to make it as clean and simple as possible. And again, leaving it up to the prosecutor, the judge, and the jury to decide those levels. But thank you. I think that's a wise decision.
Would you like to comment forward, please?
The only issue with that, I used to be a prosecutor, is that they can't do that without having the law to back them up in terms of what the sanctions might be. So we may want to consider adding those in at some point, if you'd be open to them. If you're committed to this, then that's certainly fine as well.
We'll ask Legislative Counsel to take a look at that for us and get back with maybe a legal direction kind of thing. Representative Frazier.
Madam Chair, Representative Holcomb addressed my concerns about the level of penalty. Thank you.
Okay. You want to respond in any way to that? Okay. Representative J. Neal.
I just want to add a comment about Representative Holcomb's suggestion. One of the things that the Criminal Justice Reform Council that worked so hard this past year, one of the things that they recommended in criminal justice reform was looking at some grades in certain crimes in the state of Georgia, and I anticipate we'll see some of that coming out with criminal justice reform, and if we were to move in that direction with this, I think it would be consistent with what we're trying to do with our criminal justice reform.
Any initial comments from any of our committee members? As you know today, that this was a hearing for our three bills to give the committee a little more openness in regards to what each bill does, the direction that the authors were looking at as to where they were going with the bill, what their intent was. I appreciate all of you attending today. I appreciate the order of the meeting as it has been in the past. Appreciate the pros and cons. That's what a committee system is all about, and we all certainly believe in a committee system. So with that, if there's not any further questions or remarks, this meeting stands adjourned.